And when we talk about rules and regulations, maybe you might think about human rights or constitutions or natural rights or human rights that people have by nature. And those rights could be thought by law, or else another front is understanding law like a tool, like as myself. So there's two big tied to this. But for me, I think and I try to understand law as a tool in order to make lives more convenient. So in my position, law will be making people's lives comfortable or affluent. So I talk about the comfortable or affluent, and that is now within parentheses because it's the reason that comfortableness or affluent will be different by interpretations by person. But if to think that law is a tool, Japan always thinks and says just abide by the law or follow by the law. But then the law is not about protecting the law itself, but law is about using itself. And if you change that mindset, then you will think that law is something to use, and it is now beginning to be understood that it should be updated upon the change of times. That is too natural for a tool to go on in order to make function within the society. And within today's workshops and the series of workshops, I think today your Future Ideation Camp Vol.2 was all about creating new rules. And rules is not just for the lawyers or let's say an idea is setting in within the society, within the mindset of society, then I think there could be a possibility of a bottom-up rule-making system that could be created going forward. So that is my proposal. And today I will be talking about Web3 and NFT. And when I'm speaking, basically, I would like to share what I have in mind. So if I start speaking on this topic, I can go on, and I can go on for days and nights. But let me just explain in a nutshell what I think about Web3 and NFT. So those are technologies evolution, which is decentralized, distributed-oriented technologies. And that has been evolved in the past, like internet and hypertext and P2P, or cryptography and blockchain, or else distributed ledgers and smart contracts are part of those ideas. There's probably much more to this. And using such technology, I personally think about money and wallets, and that's money or Ethereum. Those are those are the killer apps that came out. And number two, it is about content data, which are digital assets to be handled or understood in a decentralized way. And for me, I think NFT is a killer app for this area. And third is not that well known, but it is for ID and authentication, which is also an important technology for the distributed decentralized technology, where technology development is underway. And the last area is decision-making and governance. I will touch upon DAO later on. So in this boundary balance token or NFTs, within such a technological area, I think this could be an important area, and we might see other technologies coming up. So for these four key areas, I think if they are more decentralized, then I think it will be creating a worldview of a Web3 where people are just saying this very unclearly. It could be the worldview, but that is going to be probably instilled within the society. And I am mainly thinking of these four as a main. And going back to the NFT, as I have shared, the contents and data, when we handle, the technology is using decentralized technology. And I think these will be the very big candidate.
So NFT is non-fungible, immutable. So in terms of managing digital asset, NFT has advantage. And in terms of generative art, NFT is a medium or technology rather than the method. The most important message that I want to convey to you is the fact that with regard to NFT and Web3, what are they? From the perspective of legal experts, these are new methods to realize private autonomy or self-governance. As you can read there, in the private area, rules can be designed with this new method. So seen from a lawyer, legal expert, NFTs or blockchain has a certain value and meaning because it has a new way of designing rules in a private area. In terms of private autonomy, this phrase is hard to understand. If you study civil code, the law has two areas, private area and public area. So in the private area, where national government is least involved, and there is a private person in that private area, and much is left up to the freedom of a private person in that private area, and that can be referred as private autonomy. That is one of the three principles of modern law. So it's been regarded as an important part of modern law. And one possible form of that is the principle of freedom of contract. So it can be private autonomy or self-governance. So in that area, in that private area, conventionally we had contracts. This was a major means of making rules. Contract traditionally played an important role. Now we have a new method. Either contract or architecture, not a physical architecture in this case. Architecture that limits or enable certain range of behaviors and actions. So it's a structural environment, technical environment that enable certain actions. Now on the right-hand side, you see the constitutional scholar of U.S. wrote a book. Dr. Lawrence Lessig introduced this concept. This is a famous book named Code is Law. I'm pretty sure this is well known to engineers. Dr. Lessig said that there are four elements controlling human actions, four factors by him: market and norms, as well as the law and architecture. So these are the four factors. These four factors do control human actions, according to Dr. Lessig. So that is the conceptual framework. So these factors, according to Dr. Lessig, in the area of private area, there is legal contract and the architecture that existed from before. But bridging them, the architecture and contract, you can actually design both of them. And in the internet space, or the world of NFTs, what law is applied that can be designed freely because it's a private area. So applicable law can be decided amongst the participants of the blockchain. This is a detailed part of this framework. Another thing that is important is, as I said, this is a new method to realize private autonomy. So it's a new method in the private area. Naturally, the society is made of not just private area. There are other gatherings, groups. There are criminal law and financial restraints, regulations. These traditional laws would not apply to this private area. So we have issues regarding blockchain and Oracle. The externality of the blockchain has emerged as a problem. As far as we have this externality of blockchain, legal rescue, I believe, must be provided. There are other interpretations. Having said that, I do not think the world is completely programmable. So I still see the need of legal rescue and protection. And again, this is the new method in the private area. Therefore, there is always a little bit of externality, which is the source of concern that I have. So that is my concern and perspectives on Web3 and NFTs. So NFT, I believe, is a very interesting thing. So let me now explain why I think this is interesting. It's been said in many different occasions, so I'm pretty sure you know that what does it mean to own an NFT? We often refer to NFT ownership, a person owning an NFT. But legally speaking, there is no concept of owning an NFT. So the legal ownership does not apply to NFTs. According to current civil code or current law, ownership is only given to tangible objects. There's a limitation of ownership. There has been a court ruling that the Bitcoin cannot be owned. Ownership will not apply to Bitcoin. So you cannot legally own NFT. However, because of the contract is valid, you can actually trade NFTs. So the sense of owning an NFT, what does it mean? What does that mean legally and non-legally? And that is a question. In terms of the law, electronic record can be accessed by the key. So the access key, the position that you have to access that electronic record is a better expression of NFT. So being able to sell or buy NFTs, you can have the ownership or right transfer to NFT. Or when you create an NFT, you have this sensation, sense of owning a value. Surely there is a value there, new type of value. But what is it? What is that value of owning an NFT? I said that you cannot legally own an NFT. You then have to examine what is the ownership system, property rights system. So where should I look? Where's the camera? Well, I'll be looking at the slides. Anyway, this property rights system. In the modern era, the property rights system is really the fundamental system to support democracy. It is one of the fundamental legal systems. Without ownership, without property right, without this concept, our society would not function. So this property right system, before there were property that was completely shared by many without specifying who owns what. But modern property right system deals with limitedly available object. So limitation is the background. For tangible object, you may have a right to freely use the object, to use that to make profit. You may sell, you may dispose of that object. In other words, the person who owns an object is given this exclusive monopoly right to do anything about the object. So this is the right that was created. By having this concept, you can ensure the value or maximize the value of a tangible object. And this is the modern democratic system that has driven the values of tangible objects. As I said earlier, we have electronic record or digital data that are not tangible object. So they're like air. You cannot technically monopolize the object. Information can be given to somebody. It can be copied infinitely. So technically speaking, you cannot monopolize the use of that. So there is no exclusive monopoly right applied.
From such perspective, so it was considered that it was technically processable, therefore there was no idea about the ownership. However, for the intangible, there's a possibility to think and handle that there could be some rights of holding, not the ownership rights, but the holding rights, and such an idea started. So usually lawyers will think and say that intangibles will not be a subject of the ownership, but including myself, including the discussion about whether people will be able to have an ownership or holding rights on intangible goods are on the way. And I suppose people are discussing more about NFTs, and NFTs can probably not be directly applicable to the idea based on law. However, it could be indirectly related to the holding rights. And on the right-hand side, there was a series of articles in Wired, and I wrote an article on the media too. This was entitled NFT and Quasi Holding or Quasi Ownership. This word quasi ownership is a coined word for myself, but with this coin word, I wanted to try to indicate the idea of something near holding or owning.
もう一つ、じゃあ所有権制度
And
を
now
情報に
for information whether so I just been saying that there is no
実は我々はその
monopolistic
所有
rights
権に
for
メタ
intangible
バースを
goods.
持った制度が
However,
めちゃくちゃ使ってきている
we have been using institutions or regime that is very near to the idea which was near copyrights or intellectual property
知的財
rights.
産権っていうのは
Intellectual property rights
情
is
報という概
truly
念で
about
所有権に準じた
informations which is intangible and adding some monopolistic rights create the
希少性はない
pseudo scarcity to this information which is
を
intangible.
加えることで疑似的な希少性
So by granting monopoly rights, it is to give an scarcity to this information.
所有権を
The ownership, excuse me, the intellectual property rights has been based on that metaphor. So
独占権を
the in order to provide monopoly rights, the artist or the author, creators will be provided incentives.
与える代わりにそれを
So, in response to monopoly rights, then the authors will be transferring or licensing their activities, and the cost or capitals for creations will be collected
創作に
in order to
奨励するということが
channel and finance the next project.
ことが多い
That is frequently the way people explain, and this is called an incentive theory. So, such an copyright system is existing. However, there are several problems. I have written 2 problems, but even more, there's much problems to this. But then, within this context, the bigger problem or issues about the copyright system is that copyright system is metaphored on ownership system. Therefore, it is exclusive, meaning that it is admitting monopolistic rights. And the exclusive rights of copyright system, especially here, it's about art or public goods and applicable to those area. So meaning artworks have shareability, or let's say that they are public goods, and then the exclusivity for the copyright and about the shareability or the public goods. Those 2 aspects will be conflicting each other. This has been precisely or shown very largely after the internet ages. It's not just about artistic work. It could be about data sharing or private information. So once the data is accepted as an ownership or dominant monopoly rights, then it is starting to have conflict. And the other challenge for the copyright system is that, let's say, author will be selling, transfer, or licensing, then it will create profit. But then, let's say the artwork is now having much more product goods feature and then enjoyed by others. Therefore, there's only going to be one return of profit when the artwork itself is enjoyed in various front and many aspects of. There is not an area where there are the artist will be profited. In America and Europe and Asia, there are profitable way to return the profit to the artist. However, that is not included within the copyright system of Japan. Those are the problems of the copyright system, and the possibility is there that NFT could overcome such challenges, and in that sense, it is interesting. On the right-hand side, we have a capture. This is a book called Playing darts with Rembrandt. So this artist and his artworks are historical and is thought as in public goods, having a high value. However, the Rembrandt pictures owners can they play darts on his picture if he is an author? I mean, owner of the picture. Is it morally allowed or not? That is the discussion within the book, and this is about the public aspect of the artwork, and I think we should revisit such concept. Underneath that, there is the paper introduced, and this is about paper from Brian L. Fry. This is after copyright pawning. NFT is a cloud economy is about the paper. So what he says is, so of course it's just based on my interpretation, but it is about the copyright that I've been just discussing. This is about to the author return the profit and return the cost to the authors or the creators. So whether it be tangible or intangible investment to create a project will be collected. And in order to be collecting such an exclusive right will be given. And by NFT, if there should be another monetizing methodology created, then the exclusive right by the copyright no longer has a need to admit in a double-covered way. So the exclusivity of the copyright system and the conflict of the nature of the artwork that has a nature feature of a public good and just drop the exclusivity, meaning that simply put, just quit the copyright system, then the artwork could be used freely by anybody, meaning that the value of the art piece will be ever rising as a public art. So what we are discussing could be a sign of the end of the copyright system, and now it is opening up a new era. And cloud economy is about the economy giving impact. And even before the NFT through the internet and SNS, and not irrespective of the copyright system, there was the culture of the secondary creation, and not voicing out too much on the creation of the artwork. And it's right, and now it is becoming popular. So such a cloud economy is already there, and NFTs is generated, and that could be a decisive movement. So that is what the paper says.
So as you can see, he is one of those scholars who claim the new era. So in terms of NFTs and copyright, even though you sell or buy NFTs, it's not that copyrights are transferred unless you have a special agreement to enable copyright transfer. Simply trading NFT does not mean copyright is being transferred. And on a different subject, in this overall flaw, what I wrote in Wired article is the project that utilize NFT plus Commons, Creative Commons 0. So NFT could be a new monetization, and copyrighted data that is related to NFT may not be regarded as highly valuable, especially in this project. So CC0 means that you would express your intention to dispose of copyright. Of course, you can sell NFT to monetize, but combining NFT and CC0 without copyright, we will be able to maintain the public nature of NFTs and also a method to monetize for the authors and creators. So that is a possible interpretation, and that is why I introduced this project today. So copyright creates quasi-rarity, according to Professor Brian Fry. I forgot the exact words. It is the artificial rarity that is created by copyrights. So without relying on that artificial rarity, you can actually ensure the revenue sharing for authors. And at the same time, the artwork that he or she created will maintain public nature, meaning that you do not have to always rely on artificial reality. So that is one possible interpretation of NFT. So for your information, with regard to ownership, there has been a suspicious view on this. The ownership, as I said, has been the foundation of modern society, but this has been seen critical these days. Many actually claim that we need to redesign our ownership, mostly in the area of economy. The ownership actually encourage waste of assets, the value of asset. So economically, people claim that we should redesign ownership. And what I'd like to introduce here is partial common ownership. This concept of ownership is, especially for those who are in this workshop, understand radical exchange. Audrey Tan or economist Green Weil, who wrote the book Radical Market, and they are the founding members of the organization that actually advocates partial common ownership, new concept of ownership based on blockchain. On the left-hand side, that is the art example, how you can approach art with this concept of partial common ownership. It's an article I would recommend you to read. And on the right-hand side, it's the radical exchange president who came over. I actually had a talk, and there is a Japanese article about that talk with him. So just briefly, this is a very difficult concept to explain, and this will drive interpreters crazy. So let me just give you a brief idea of this ownership. So ownership, which means that there are people who have, the rich people who have majority of the global asset. But time is limited. Even though they have everything, they would not be able to use it effectively. It's a lot of waste, according to economists. If part of that asset is liquidated, the value of wealth is going to be enhanced and elevated. Naturally, the value will expand. So we respect ownership, but for a certain period of time, the assets that are held can be shared with others. So sharing that, the right to share asset can be introduced into auction. The right can be transferred to the highest bidder in the auction. So it's a mechanical design or a market design, the economic design that is applied using blockchain. I'm not technically savvy, but there is a GitHub. If you're interested, please visit the GitHub site. Now, Vitalik, solvent token or untransferable token, he has written papers and books on those topics. So the Radical Exchange, the organization that I mentioned, have done a lot of technical and legal experiments. Very, very interesting organization. How long do I have? It's up to 8:40. Okay, then I still have time. I was talking with interpreters before this, and they asked me not to. Well, I wasn't exactly asked, but we were jokingly saying this is the hardest slide to translate. And that's true. This is the most important and difficult. And I'm pretty sure this slide makes you a bit sleepy. It's not just instantly understandable. So when you encounter a situation like this, you might want to consult with an expert. So I just want to explain rough idea about the legal nature of NFTs. Some people might love this topic. So NFT or blockchains or Web3, when we talk about them, we do need to consider the legal nature. So securities or crypto assets, I gave question marks to that. ERC20, if you use ERC20 to create a token, this problem will be exaggerated. ERC721, if you use ERC721 for NFT, also you have to think about this issue of legal nature of NFTs. What I mean by this is that, so how are we going to design NFT technically? At the bottom of the slide, NFT could, or the gambling crime law may apply to NFT, depending on how you use it. So there are also penal code or criminal laws need to be considered, because blockchain and NFTs, once again, are a method of rule-making in the private area. So as I said, there is always externality. You would not be able to escape the public regulations. So NFTs, on the right-hand side, I believe Masashi-san had shared this presentation with you beforehand. This is a guideline issued by Japan Crypto Asset Business Association. This is a guideline for NFT business. It is a flow chart that can be used for NFT business as well as NFT creations. So this is a flow chart. This is completely made public. Anybody would be able to access this and see. This is non-fungible token, ERC721, likes of that. So the question you have to ask first is there revenue sharing? If there is revenue sharing, this makes the securities law to apply. the financial instrument and exchange law may apply. Even without this revenue sharing, is there a economic function like payment settlement, prepayment or cryptocurrency payment and so forth? Especially, you have to be careful about cryptocurrency payment. If there's no payment like this, it is unlikely that your NFT will violate the Japanese internal law. So is there revenue sharing? That is the first question you have to ask. Is there any payment economic function available? So these two questions need to be asked. And one more thing. NFT art royalty distribution often comes with NFT art. This royalty distribution is different from revenue sharing. Even though you actually distribute royalty, securities law would not apply. It's very hard to explain why these are two different things. I just want to give you the conclusion. Also, settlement or the payment. Is there a payment method available or not? Whether you can use cryptocurrency for the payment. This is an important question to ask. NFT is non-fungible, so each NFT is unique. There is only one NFT. I cannot highlight, but since this is non-fungible, essentially, in principle, it should not have payment function in it. So whatever that is named NFT, especially NFT art, in many cases, it's not going to be treated as cryptocurrency. But if it's not art, it can be collectible, or it can be used for a game. In many cases, this type of NFT may be regarded as cryptocurrency. In 2023, Financial Supervisory Agency made a public comment. This sorted many problems. It set a trading value threshold and also the number of issues, whether that is over 1 million or not. These are some of the questions that the FS, Financial Supervision Agency, presented. So initially it may be a unique NFT, but this can be utilized secondary. If there is secondary usage, this may be involving payment. So maybe in the beginning it is a unique object, intangible object, but it could be changed because of the added payment. NFT is often referred to as non-random payment. Unless you have random sales, you may be concerned about the criminal the gambling law, which may possibly apply to random sales of NFTs.
And everybody, has been working on DAO. I saw that you were working on DAO within the workshop yesterday or 2 days ago. So I created a DAO slide too to follow your work. So how to define DAO? There's many ways to define. And I myself take it very cool. Oh, well, not meaning great looking, but I try to look at it in a severe way. So this is a community to make decisions using governance token. That is what I find or define DAO. Maybe there could be more philosophy to this, or a more larger way to take it. However, I do believe that DAO is an organization or community making decisions through governance token. And regarding DAO, the governance token, what kind of a legal nature is there is on the discussion, and then leading to the discussion I have just leading. So when distributing business profit could be allowed or applied to or discussed about whether it is a securities related nature based on the financial law. The governance token as a business, when you have to make the decisions based on your business, you have to be having such a way to make decision, and that is about the profit made on the business. And it should be, if the function is there, it is easy for sharing or splitting the profits for the members. So if you are going to be sharing such profits or splitting the profit together with the members, then you might have a possibility of violating the financial securities law. So yes, regarding governance token, if you have a means of settlement, then it could be that the cryptocurrency could be allowed. But if you are splitting up the profit by the community, you could be violating the securities law. And for unspecified parties, this falls under category of cryptographic assets. And for governance token, there's a necessity to determine whether it could be used for NFTs or not. But first of all, we have to think about the legal nature of DAO. Currently, the partnership, meaning that a specific group that has specific purpose and got together, and this is based on Japanese law or the legal cases, meaning that this is an association without rights based on Japanese law. So what I mean by this is a partnership or an organization association without rights. They are not having the liability of incorporation. They do not have legal capacity. If they are a legal capacity, then a new type of business law or corporate law could be written, and according to law, it could be a specified purpose organization. SPC could be used as a methodology or a trial. And if needed, if some people would like to use a legal capacity, those are the way. However, if there are no usage for that, then usually there are no legal capacity, meaning that the partnership will be having an infinite responsibility, meaning that whatever DAO has done, a third party has been damaged and claims for the damage. And if that claim is heading for the member of the DAO, even if the member is constituting only 1% of the member, this person could be questioned and will be subjected for all his properties, including his properties and everything included within the association. That is infinite responsibility, and that is residing in current DAO. So on the opposite, what is an unlimited liability responsibility? So there could be that the control of the asset is ruled in a meticulous way. This is not a partnership, but is considered or admitted as an association without rights, which is based on the court ruling in Japan. And association without rights, the good thing is that the membership is not going to be having an infinite responsibility. They will be having finite responsibility. Therefore, if you are asked for some damage and claims, it will not expand into your own assets. It is only about the responsibility for the organization. So what you need to be careful when you are creating such community, you have to create a partnership rule and to clarify your role or responsibility. And you have to be thinking and stipulating the responsibility about the organization or incorporated associations. By having that as much as possible, you should be creating a society that is near as much as possible to an incorporated legal capacity. So going forward, there could be some regulations created, especially in Japan, which is led by LDP, Liberal Democratic Party, and they are focused on Web3. Therefore, there could be a necessity that companies will be making their business on DAO or Web3. Or, as I mentioned, the court ruling, it could be based on the incorporate legal capacity. But then, can that be applied to DAO or not using smart contract? We don't know yet. We don't know. It's beyond the horizon. And maybe you might see a partnership. And then that could lead that your personal asset could be subjected to the responsibility. And if that happens, then you will just shy away from DAO because the transaction will not sound safe and sound yet. Therefore, the discussion of people accepting DAO as the legal capacity could start working in discussion. This is my last slide. So I've been going through various issues. Maybe it could strike you and made some sense to you, maybe some not, but principally the possibility of NFT art. So whether or not you're truly creating art or not, I'm not quite sure. I don't know about that. But I'm just talking about the possibility of the art. And me, NFT is going into the private autonomous area. It's a rule designed for self autonomy. And I think this is going to be a tool needed. And when just organizing the law and architecture seems to sound so separate. So how to design them in both area from each of the different area, we must take a balance. And I wrote a book about the balancing about the legality and the art, which I mentioned about this balancing. And there's a possibility that we can do this balancing all at once at the same time. And then it has scalability. It's free. It's very. So it seems very appealing. And I'm not a creator of NFT art, and maybe I might mint, but I'm not a producer of art. But I feel appealed that, and I feel appealed, and this I think is a necessity in the context of modern arts. Many people say this, that conceptual arts and such a technology has a good affinity. So designing the rule itself could be created into an art piece, and such a movement is observable. And this NFT and blockchain design synchronizes, and the smart contract design synchronizes with such movement of art. is what I feel.
あとはですね、
Now, I said this when I was talking about copyright. I do not want to abolish the copyright system, but since we have had ownership system, we want to use that flexibly. Creative Commons is to use contract to enhance flexibility of ownership. So NFT and smart contracts, in terms of contract and architecture design, can be made more flexible. Especially the additions of work and the reality of the work and quasi-ownership of NFT and also the public nature of art, all of these can be satisfied at the same time. And there is a high possibility of realizing that. So in trading NFTs, normally you would not transfer copyright, but more than copyright admits, licensing can be given to the collector, the owner of NFTs. Licensing can be very, very interesting. Licensing and contract can be an interesting experiment where many different attempts have been made. And OpenSea is not as popular as it used to be. Some of the functions were stopped, and there have been technical glitches in the OpenSea. Having said that, we do see a problem of copyright. That is for authors and creators to only have only one-time investment recovery to receive the return. So this could enable continuous revenue sharing, ensuring returns given to contributors, including artists and creators. So we believe that better solutions are yet to come. I have great expectation there. The remuneration is given utilizing marketplace, but I believe that smart contract can be utilized instead. I think I am done a little bit before the schedule, the time. I make sure this presentation is shared with all of you at a later date. So this concludes my presentation. Thank you for listening. Thank you, Ms. Lo-san, for a valuable presentation. We would like to open the floor for Q&A, but first I'd like to invite Ito-san, Technical Director, to join us over here. So two of you will be sitting there. That scares me a bit. Well, in terms of time, I think we can have discussion, the mutual exchanges here before taking questions. This has been a good learning session. NFTs and generative arts, we can use blockchain for artists to express their creativity. It's been done over the 2 years. What I have been doing, for example, in terms of internal law, whether what I have been doing is safe enough. And Toshiaki Takase, the corporation that we jointly organized, and its activities can also be regarded from the legal perspective. Private autonomy or self-governance are a very good fit for what I do. Generative mask is the NFT project that I have. I like to sustain that, and eventually we would like to create a public genre of generative art, and that is what I'm trying to achieve, observing and abiding by the internal laws. So in the private area, how can I achieve this? So now I know what I am, what challenge that I have in this area. So it was a good understanding, a very good learning for me. Having said that, well, excuse me, maybe you can go back to my major slide. You know, the cool looking slide. Yes, that's the one, the title slide. Rather than showing my memos and comments on the screen. Sorry. So this has been a very encouraging message that I found in your presentation. So when you talked about DAOs, Mr. Mizuno, you are looking at this from cool-minded perspective. This was a bit surprise. In the area of Web3, you see a great possibility there. Well, in that sense, maybe what I said was misleading. DAOs, I believe, do have great possibilities, depending on how you define it, but the overall direction of DAOs is something that I have agreed with. And when you look at the formation of companies, it is one of the greatest invention in the modern society. So if we are going to redesign an organization that is named company, DAOs could be a very impacting way of thought. But legally speaking, you need to be practical, as if you are looking and interpreting Web3 legally. So that's the perspective that I applied. So as I listened to your presentation, there is a risk of casually organizing DAO, but rather than doing so, you talked about association without rights. Yes, the association without rights. Maybe you don't need to learn that word, but association without right, without the legal capacity. So you have to create the format as an association without legal capacity. This is good for anybody who would like to create a DAO. Yes, that is one way that you can do in terms of organizing DAO legally. Majority of organizations that are named DAOs, majority of them are acting as if they are DAOs. You may have noticed off-chain governance. I wrote that on some of the slides. So they actually have a mixed organization. It's mixed with a company or a union or partnership. No one is really consciously designing DAO yet. So Ito-san, I do have a question. So in this camp 2 days ago, we came up with interim work. You use Solidity code to create something like currency. There are different units. And yesterday, we created NFTs. Was it 2 days ago? And yesterday, we created DAOs too to share wallets. And we've done a lot of experiments in the camp. So if we continue to use those tools that we created for fun to apply to other areas, where do we have to draw a line? From where beyond, for example, if I send original currency to somebody else in the group, it's limited in the group. If it's used as if it's a currency, when do we have to be worried? So it's a very difficult question. Well, I'm pretty sure you dare ask that difficult question to me, but of course there are multiple projects. So financial authority will not come and get you. So meaning there is a lot of gray area, right? But if you do that as profit-making business, and if you repeat that business activities, the laws would apply. So that's the best I can say to answer that question. But there are a lot of things that you are not aware, and there is a possibility that what you do violate the law. And also detectability is something that you also have to consider. So in terms of risk, it's a relative concept, but substantial risk is minimal, I think. Thank you for answering that difficult question for me.
So one comment, I'm not trying to expand such an activity. I would like to abide by the law. So let us pick up some questions from the floor. Anybody who has any questions? Oh, there's a lot of hands up. Thank you. Thank you very much for your very insightful talk. I have two questions. One is about my feedback, my observation. So using the copyright as a tool, about that concept, within the patent in Japan, when you acquire a patent, it is considered to protect something. However, there's a rewrite or update of the corporate governance law. Therefore, the companies in corporations should use the patent more aggressively. Such an idea is starting. So when you just started saying that copyright is a tool, it was stimulating, inspiring, because I got what you are saying. And second issue, this is going to be my question. So Tokyo District Court has handed out a court justice for Bitcoin. It was about the Civil Code article 280. And you've been mentioning about the right to track down the issue. There is a right in overseas legal area. However, in Japan, there is no right having a legal backup within tracking down the process. So let's say when there is a revisal of the law, if there's a retrogressive way to about the resale rights, how do you think about this? Thank you so much. That's a very good question about resale rights, and I think there's two ways. For instance, the system for resale rights, it is possible even today to embed that within your contracts. Let's say I am working at a company called the Start Band as an outside auditors, and here the resale right has been so within their contract, they had some resale rights within their contract when the company has been transaction. So that was a service provided from that organization. And Start Ban is one case. And for me, when I when I am selling the art piece and make a contract for the art makers to the art collectors, when the artwork is sold at the primary sale, selling it over to the collector, the condition says that when this is going to be resold, some percentage should be coming back to the artist and the gallery. If that condition is embedded within the contract, the resale rights will be followed. The smart contract that is having a nature that is asking such resale rights automatically. However, contract-wise and legal-wise, once you can put it in your contract, that could be possible for tracking down and executing the resale rights. However, regarding the resale, let's say the collector further resold, in that sense, in that timing, there needs to be have another conditions so that the reseller collector will be paying for several percentage to the artist and the gallery, or else the chain will be broken. Thank you very much. So the resale rights overseas, I would like to know about the background, why it has been created. The resale rights, as mentioned, it was about coming from the issue from the copyright system. It has to be embedded within the contract, or else the art piece and the contents value that it should have, the artist should be giving back the compensation that he has been putting in order to have his creation made. And especially when the resale is done, resale should be having a larger money created. However, it is not recollected to the artist itself. And that was, by the way, whether to introduce this in Japan or not was discussed too, for instance, led by the Cultural Agency of Japan. So there's already an article and a paper on this. If you have interest, please do read. Thank you. Thank you very much for your valuable issue. So I have a radio program called Cross, and we've been having a Metaverse 10 exhibition the other day. And the URL, I have been having a digital address, and people were uploading their product. And one person who is working for a game company, and he is a master of tea, and he created a tea bowl, and then he uploaded his tea bowl art on top of our platform. And this was his very first time that he has responded and uploaded his art on digital. And here today at Tobu Hotel, here we have the data. And this time, what we did with our team here is about the future coins and future money. It could be art too, but then the real actual product is here. And we're creating art on digital platform to create some value onto it. So we have the actual substances, and linked to that, it's going to be uploaded on digital. So you mean by adding value, adding information on the digital platform, you would like to add on the value to the real substances. And the curator here has been commenting that I should be much more clear about digital condition and the real condition. And the NFT information, the address is now linked to the Tobu Hotel, the workshop address here, meaning that tangible substances is now linked to an intangible to some way. And it is difficult for me to just organize my mind, but is it going to happen going forward? Yes, that could happen. Even today it's happening. So there's a unique technology that you have to visit one place in a unique locality where you can just enjoy these substances there. And if the place is open to everybody, once you visit, then everybody can enjoy. For instance, you can enjoy the exhibited art or music played at the venue. But then the NFT doing something near similar to ticketing that is at the venue at that temporal time is where people can enjoy. But as I heard of such idea at least, however, I have never gone through the experience. But what I mean to say is, such an idea it could be possible, and it could be possible going forward, and maybe it could be related to patent as well. I don't know how to do this or perform this. So you mean a quasi intangibility? You should create and how to link it over. Regarding intangibility, maybe you can limit the number of putting it over to the NFT. For instance, let's say several 10,000s of people or 100,000 of people will be going through traveling around Shibuya. However, only a percentage of that travelers can only enjoy the work, and that could be some rarity. You mentioned about the exclusive right, which will be maximizing the intangible asset. So how should we understand this? So by having exclusivity, by trading, selling, purchasing, or enjoying, this is a desire of human, and making that desire as a right raise the value of the object, because this is capitalism, and if people would like to have access to that substances even more, then there's going to be added value even more. So starting March 1st, let's say I already have an asset, and then the timeline is infinite. Is it so? There's an expiration timing. However, it is almost a semi-infinite. So when the schedule is put into data, then by adding digital information, it is going to be even more informative. I don't know if I understand you correctly, but it is in a very interesting way. The partial common ownership could be connected to what you have just mentioned. So within a certain timeline, the profit could be used freely. Such a right could be auctioned, which is within a limited timing or limited term. And then for the highest bidder, the right will go. And then by that, the right could be raised higher in pricing. So it looks like anti-capitalism, but then it is economically capitalistic. So such an approach could be possible.
るかどうかわかんないですけど。
ありがとうございます。
Thank you. So please go ahead. Thank you for sharing valuable presentation. In our group, we were discussing eliminating copyrights for art so that we can design the marketplace and give shapes to the market, and that's what we are doing. And we talked about smart contract, and it's just an idea right now. Contributors to NFT art, for that contribution, the profit can be shared. And realizing that with smart contract, I think it's a challenge, whether it's possible or not. And as I said, the resale right can be claimed as the legal right. In other words, it can be embedded in a smart contract. In other words, if we issue a smart contract, that ensures there will be resale right that is legally protected. Designing a smart contract, you cannot redesign the law. To change and rewrite the law, you have to go through democratic procedure. In other words, this will have to be presented and discussed and approved in the Diet, unless otherwise the law cannot be changed. Depending on what is the definition of the law, you cannot change the law by smart contract, but you can change the rules by writing a smart contract. So the rules inside a DAO, or on the blockchain network, or in the marketplace, you can write new rules in the contract. To change the rules, so do we have to define a DAO or a certain agreement on DAO or guidebook that we write? The rules will be there in the definition or the guidebook. That's what we can do in the beginning. Is that correct? Yes, that is right. Thank you. Other questions or any feedback that you want to share? Yes. I don't want to take his question. Thank you for a valuable presentation. I have two questions. Two? Oh, I just ask one question then. So, giving ownership to data about this topic. In another event, Mr. Mizuno applying ownership to data. I asked the question whether it's possible to give ownership to data, and you said that data is liquid, so we have to be cautious about that, and you are opposing that idea of giving ownership to data. It was an interesting reply. So since then, some time passed, has there been any change to that interpretation? And you talked about quasi-ownership that you discussed. On Saturday of this camp, we had Masaki Fujihata, the media artist, made a presentation. He talked about the Brave New Common, my first digital data, his artworks. And he introduced a system where an increasing number of purchasers, along with that increase, it makes the artwork more public because multiple people own this. And I think what he explained in these artworks is similar to what you were explaining. So I better understand it now. So in terms of democratic thoughts, it's far from there because multiple people altogether have the ownership of an artwork. It's a new way of ownership. It looks to me that it's remote from the traditional democracy. So what is your thought on this? Thank you. I thought you might ask difficult question about cryptocurrency. So about data ownership, I still do not believe in exclusivity of data ownership. So with regard to NFTs, quasi-ownership, should we bring this concept to NFTs? I have not come to the conclusion yet. It's very difficult to differentiate, although I gave you a positive observation of this. If you want to promote ownership, it is possible to assume an ownership like that. But the large principle is that exclusive data, it depends on what right you give to data. If it's ownership like exclusivity of data, the data value, information value, will be deteriorated. so that actually damages the public nature, and my belief has not been changed. So secondly, the artworks created by Mr. Fujihata, as you rightly explained, whether it is intangible or tangible, the same rules may apply. The resources to produce an artwork, who spends for those resources, and who else will be able to share and support to obtain resources. It is an abstract concept, but it's a bit like socialist approach. So how resources are used by multiple users, how can users help each other? With that approach, the more you use the resources, each person's burden will be minimized. That's the logical necessity. It's a set of resources that you require. If there are more people who participate in procuring those resources, in the technical term, it is the marginal expenses. From that perspective, I think it is reasonable to have multiple users sharing the resources. And if that is utilized for artwork, it can be interpreted as a proposal for new rule making. But postmodern democracy has not been operated or executed depending on this concept of marginal expenses. As you asked early on, sometimes artwork is very expensive, prohibitive expensive, not accessible, by simply keeping it somewhere that is not visible, utilizing the market power or market force. Using the greed of humanity, you can maximize the value of the artwork that is sort of contained, not made open. It's a completely different logic. Of course, some experts disagree with me, but how these two different logics merge is the possibility. I am not sure whether I answered your question correctly or not. Thank you. I was speaking as I was thinking. So maybe we could have another opportunity to continue to listen, and the exchanges will continue on another occasion, but our time's up. So we would like to conclude the fourth keynote presentation. Once again, please give Mr. Mizuno another round of applause. Also, for those who are participating here and online, there is this housekeeping announcement from CCBT. August 26th to 31st for the 5 days. At CCBT, we have a 5-day Future Ideation Camp Vol.2 setup. That is exhibition. The theme here is making new rules with blockchains. We have 24 participants right now, and we had international lecturers discussing the basic mechanisms of blockchain, currency, NFTs, and DAOs. So we are taking this challenge of making new rules with blockchains. 2 days from today, from August 31st to September 3rd, we are going to have exhibitions. Participants' work will be displayed from 1 p.m. to 9 p.m. at CCBT Civic Creative Village Tokyo. This exhibition is held. It's free of charge. So you can come to enjoy the expressions using blockchain. If you're interested, please come visit us. Thank you for your participation. Thank you.